Okay, let's go on the record then. Good morning. This is a pre-hearing conference in Public Service Board Docket 8774, investigation pursuant to 30 DSA sections 30 and 209 and Public Service Board Rule 5.110D into alleged violations of Certificate of Public Good number NF-1771 concerning the construction and operation of a group net metered wind electric generation facility located in Irasburg, Vermont. My name is John Cotter. I'm a staff attorney at the Public Service Board, and I've been appointed to as hearing officer in this proceeding. And let's start out by taking appearances, please.
Jeannie Ice with the Department of Public Service, appearing today on behalf of Megan Ludwig, who recently filed an appearance in this case, and will be the Department Counsel.
Leslie Welts, on behalf of Agency of Natural Resources.
Rusty Cattle, legal counsel and advocates for the respondent, David Blittersdorf.
Rick Dingleby, and the Crossing Committee for any question on behalf of Mr. Buckley.
I understand that you were bringing a motion to
And I would have loved to do that, but unfortunately, I just got my computer back from Orange Street's computers. We've had a little meltdown, malware attack, so I was unable to draft that yesterday. But I will send that in this afternoon.
Okay, thank you very much.
And we do intend to file a motion to intervene as well.
Okay. So have folks discussed amongst themselves not just a schedule, but a structure for this proceeding? This is a little bit out of the ordinary.
Well, I tried, but failed to get any input, and I understand that the department's going to let us know what they think the procedure will be today.
Oh, okay.
And Ms. Cadwell is correct. The department had to do some thinking, given the unusual or atypical posture of this case, about the best way to proceed. And as is often the case, it took a while to gather the department personnel, and we barely finished doing that before we could come this morning. So I haven't had an opportunity to discuss with Ms. Cadwell or with Ms. Dingleby the department's thinking on this. So, oh, it's the Leslies. I get confused. So sorry.
I'm anxiously awaiting to hear as well.
What I would like to do is to take a few moments to give the parties and the board the benefit of the department's thinking on this, and then open it up to board questions and have hopefully productive discussion on things. Also knowing that I was playing catch up on Ms. Ludwig's case and the facts that have already that led to the filing of the open this investigation. That's a real time catch up. This case, as everybody here knows, began with a complaint of an individual. That was a petition to revoke the CPG, which the board in its order opening the investigation characterized as a complaint that the CPG is not being complied with. The department views the process of investigating a violation of a CPG and the potential imposition of penalties for those violations as a two-phase process. The first phase of the process we see as determination of the existence of a violation or not. Because if there's no violation, don't proceed to phase two. You're done with the matter. So that's one thing that we believe is important to keep in mind as we proceed down this road. Is there a violation or not as phase one? If so, then penalties and sanctions come into play. In this case, the board, I believe based on the reading that I did of the file, asked the holder of the CPG to respond to the assertions made by a neighbor that the CPG was not being complied with, and the holder of the CPG elected not to respond to that. So the parties find themselves in a posture where there is an allegation, but there has been no investigation. The department views the holder of this CPG as subject to the board's jurisdiction. The department does not view itself in any way analogous to a prosecutor who has to go out and do an investigation. There certainly needs to be a process initiated here to develop the facts upon which the department and all other parties can make recommendations to the board on whether they think a violation has occurred. And that's, I think, what we need to address in phase one. The department reviewed the penalty statute of the board and reviewed 30 VSA 32G as the appropriate vehicle for determining, for initiating the factual investigation into whether there's a violation. That subsection of the statute basically requires the person under the jurisdiction of the board or the company, in this case the holder of the CPG, to affirm that they are in compliance with their CPG. The affirmation in this case should be requested in great detail, and the filing of, in the motion to revoke the CPG makes specific allegations and could serve as a good model for the board's order under 30 VSA 2G for the request of the CPG holder to either confirm or explain whether they're in compliance with the CPG with respect to the specific allegations that were made in the petition to revoke. And the department thinks that, in this case, is the proper way to begin the factual development to determine if there's a violation. After that filing of that affidavit, there can be some discovery. I think we have to see what the results of that affidavit filing are to determine the process going forward. There could be discovery, there could be a technical hearing, and if so, then the procedural way forward is very, very simple, because during the course of discovery, parties can make up their mind about whether there is a violation, and if so, continue the discovery to look into any of the information that a party seeks to develop with respect to the 30 VSA 30 aggravating and mitigating circumstances and other penalty criteria. So that's the department's thinking in terms of how to proceed, that we use the vehicle that is in the statute in order to get some factual development, because right now we have one allegation and nothing else, and we need a factual basis going forward to develop it and something to do discovery on. So that's how the department sees this matter proceed.
Okay, why don't we hear from Ms. Cadwell next? Any response?
Only that I think that there's a slight mischaracterization on what the board asked in its memo after Mr. Garthwaite filed a petition. It wasn't a motion, it was actually a petition that was never served on my client. And the board did not ask to respond to the allegations, it just asked to respond to the petition. We expected the petitioner, as I guess like a consumer complaint, to actually comply with the rules. And in that way, I just disagree with Ms. Elias. I don't think the board's order asked to address the specific allegations was pretty general. But notwithstanding that, the board does have the authority and has. I've had a client recently be asked to submit an affidavit under Section 30 as a way to resolve a petition or a consumer complaint. In that case, it was just a complaint as opposed to a formal petition filed by an attorney. So that's an appropriate way for the board to proceed. I don't think the section 30, this is the first time I've heard this argument from the department, so I'm making some arguments off the cuff in response. I don't think that the statute requires an affidavit. You can certainly ask for one. That wasn't what was asked for in the memorandum, as it has been in other cases. I do think the department does have an obligation to conduct an investigation. Its responsibilities under Section 2 are to supervise the laws under Title 30. In my own experience, having sat in Ms. Elias's chair, I supervised lots of investigations, allegations of both consumer complaints, complaints against utilities. In my own experience, what would happen is the department would actually conduct an investigation to determine whether there was reason to involve the board and have the board's resources devoted to an allegation that was unsworn and not proven. So I don't, my own view is that there is an obligation to establish the facts. If Mr. Garthwaite has made allegations, it's up to Mr. Garthwaite to present a case for the respondent to understand what exactly the allegations are, whether they're material to the certificate of public good, both the installation and operation of the, in this case, 2 residential wind turbines, whether that's Mr. Garthwaite or the department in its role as representing the interests of the people of the state here. It doesn't really make that much of a difference from our perspective. But if what the board thinks is appropriate is to have the respondent file an affidavit that he's in compliance with CPG that was issued, that's certainly the board's prerogative, and the respondent will provide that affidavit.
May I just respond to a few of those?
Sure.
Ms. Cadwell is right that I didn't mention the procedural matter. So I think she represents it correctly, and I apologize for not having done that. The board's memo simply asked that Mr. Blittersdorf file written responses to the petition. I just looked at the board's memo, and that's what I was referring to. I just wanted to correct any of the statements before Ms. Dingledine had to proceed. And Ms. Cadwell is right that she didn't hear this thinking on behalf of the department until just now, and she was handicapped in terms of preparing a response. She did have to do it on the fly. The department is aware of one other instance, at least, although I don't have the citation here today, where the board did require, with great specificity, an affidavit under 30 VSA 2G that was not just a question, are you in compliance, but specific factual allegations that needed to be addressed in that affidavit. And under 30 VSA 2G, the board has the authority at any time to require that. And that, I think, is the appropriate way to develop the beginning of the factual record so that the department can do its job and look at the facts, ask other facts using the discovery process, and then develop the recommendation that we make to the board. Okay. So thank you for letting me dive in.
Ms. Dinkley?
Thanks, Mr. Cutter. I'm here representing an individual landowner who was originally served with notice of Mr. Blittersdorf's request for a CPG. And based on the representations in the application in terms of the location for his construction, my client reasonably relied upon that information, which indicated that it would be more than a mile away from his home, according to the information we provided in the petition, which is based on his personal knowledge, it was not submitted under oath, but certainly it was provided to the Public Service Board to review the situation, because we feel it's very important that if the representations within an application turn out not to be correct, or the construction occurs in a place that's substantially different than what was originally represented, then in effect the landowning folks that could be affected may be allowed intervention because they're able to demonstrate impacts, and that they ought to be heard in terms of the permitting of this kind of facility. It's very important that the board be able to rely on those representations. If in fact the information that we've provided bears out to be true, we do believe that the CPG representations were not accurate. How that ended up coming about, we think it is certainly a public issue. We have provided a number of residences that do in fact are very close proximity to this, and closer proximity than what was represented to the board. So from my client's perspective, he was robbed of the opportunity to be heard on this, to discuss what the impacts would be on his residents, and also raises the issue that there are a number of other folks in the area who similarly should have received notice and were not advised of this, and who may in fact have an interest that needs to be considered through this process. So we do agree with the department in terms of the board's continuing jurisdiction over its CPGs and over its process from start to finish, including what that application actually indicates for the representations that the board has taken as being valid. So from our perspective, we're not so worried about which process has gone through so long as there is due process. And due process should include proper notice and an opportunity to be heard on this if in fact it can be demonstrated that Mr. Garthwaite or others in the community do have particularized interests such that their positions and concerns and the impacts to them are valid and should be considered by the board in relation to the permitting originally or the continued permitting. So we are prepared to provide information through discovery, information under oath. My client is an open book in terms of what he has observed, the impacts to him, what information he's gathered about the location, as well as the neighboring properties that he also believes should have notice to this. So we are willing to engage in discovery, either providing information. As I said, we will be filing a motion to convene because we would also like the opportunity to gather information from the applicant so that we are able to provide relevant facts and demonstrate the impacts that Mr. Garthwaite indicated in his petition that he is experiencing. I do want to just state for the record that I was unaware of the April 15th order of the board until yesterday, nor did I receive the current order that indicated there would be a hearing today. I spoke with the deputy clerk Tuesday on this, wondering, gee, when is this hearing going to go forward this week? And we've determined that we have not received anything at my office on this case. That's actually why, when I had not heard anything, I requested a summons from the clerk to comply with the issues that Ms. Cadwell had raised in terms of the procedural requirements that she had raised, so that we could satisfy those objections, whether they were valid or invalid. We weren't taking issue with it. We were just trying to remedy the concerns that Ms. Cadwell had so that this case could move forward. So if we're a little bit playing catch-up here, it's simply because I had not seen the board order setting this hearing until yesterday, and I had never, when I read that, I realized that on April 15th, a board order had issued that I had not seen. So we're happy to cooperate in any way, but we would like to ensure that due process is followed through whatever process that the board chooses to go through.
I'm honestly not sure why you didn't get this order, because you're on the service list, so that address is correct, so.
Yeah, and we verified all that. I don't know.
Yeah, and just to be clear, the correct record, the document you're referring to is just a memo from the board, it wasn't an order, it was a memorandum requesting a response from this board as well. Ms. Wells?
Sure, I'm happy to comment. So A&R's interest in this docket is obviously a little bit more narrow than all the other parties. It's my understanding, and I will confirm this with my client, that A&R did not originally comment on the CPG application when it came in. I'm getting a nod from Ms. Cadwell here. So our interest is partially, obviously, we're interested in following the application process in general and what are the natural resources impacts on a particular site. And we may be able to offer comments and recommendations regarding penalty calculations as they pertain to impacts on natural resources from if it is found that a violation has indeed occurred. But before we get there, A&R agrees that it makes sense to follow the 30 VSA 30G process first, have an affidavit file calling for, have the board call for an affidavit that speaks to whether Mr. Blittersdorf is in compliance with the CPG first. Then it could be appropriate to move into 30 VSA 30A if it is questionable whether a violation has occurred, and discovery could be conducted under that part of the process. And if that part is concluded that there is a violation, then it could be moved into 30 VSA section 30B, where the penalty calculations and sanctions are briefed and argued. Oh, see? I must have written it down wrong in my notes. Well, the penalty calculations provision. Thank you. So, I think it really, A&R has a broad interest in ensuring that the applications that it reviews and makes recommendations on are the ones that are being, the CPG that is issued, that we review generally. When a CPG is issued, A&R reviews to ensure that it follows the application. As I said, we didn't review this application, so it's a little bit limited applicability here. But in a general matter, we review it to ensure that it follows what was requested, and if it doesn't, then it seems sort of useless to have offered recommendations of how to site a project to avoid impacts. So we do have an interest in ensuring that the recommendations that we provide, on which the board relies, and when the board issues an order, that is followed. So that's A&R's interest, and I think that it makes a lot of sense to just begin with 30 VSA 30G. We can move from there.
Okay. Yes, Ms. Cadwell?
May I respond?
Sure.
First, I think it's important, particularly in light of Mr. Garthwaite's representations. The dwelling is not a residence. It's actually a hunting camp with no potable, no wastewater system, no permanent wastewater system in any event. So I think it's insofar as there are facts that need to be developed, establishing to the extent that this is an investigation of Mr. Garthwaite's allegations, understanding what are the true facts, in addition to whether the applicant is in compliance with the CPG, are important. There was nothing that I saw in the petition where an allegation that adjoining landowners were not properly notified. If there's a suggestion that notification was required of other people, who are not adjoining landowners. I don't think that that's a fair reading of the law. In my experience, at least the law at the time was adjoining landowners get notice, and there's nothing in the petition that said adjoining landowners didn't get notice. Finally, I do think it is important for whatever path we go down, that the application and the law that was in effect at the time the board reviewed the application is the law that applies to whether the wind turbines were installed in compliance with the CPG. There has been an evolution over time on the application form. The application form today looks very different than it did in 2009 or 10. I understand the application form that was used at that time was developed in 2009. It wasn't changed again, I think, until either 2011 or 2013. And the current application requires a significant additional information, or is more specific in guiding applicants through the process. So I just want to put that on the record, that I think you can't be looking at compliance under the application as it stands today. It's what was required at the time, and whether the project was constructed or installed in compliance with the representations and the board's order.
Yes, Ms. Lawrence?
Just one point. I think Ms. Cadwell's recent comments illustrate, from a practical perspective, why the department's suggestion makes sense. Ms. Cadwell's client knows the location of its wind turbine better than potentially anyone else. And the filing of an affidavit of compliance is in that client's best interests, I think. And I think that's I don't have the legislative history of the subsection under which I think the board should operate here, but I suspect that the reason the board was given that tool in the legislative universe is an acknowledgement of the fact that not only is an entity holding the CPG under the board's jurisdiction, but that it, from a